Today on Know Your Rights New Jersey, we address the nuts and bolts of immigration law and policy. This segment will help viewers understand some of the key issues around immigration and offer some pointers for navigating the system. Today we have joining us attorney David H. Nachman, a highly respected authority on immigration law. David, thank you for joining us.
You're very welcome. Thanks for having me.
David, before we start to getting into the nuts and bolts, can you give us a little bit about your wonderful, extensive background?
Sure, absolutely. First of all, thank you very much for having me today. I really appreciate it. And just to tell you a little bit about our firm, I'm one of the managing attorneys at the NPZ Law Group. It's Nachman, Fulwani, and Zemochek. We have offices located in Ridgewood, New Jersey, and we also have a small office out in Indianapolis. And what makes us a little different from other immigration firms in the United States is we have an office located in Mumbai, and we also have an office located in Canada. So we're also doing outbound immigration work as well as inbound, because as you can imagine, sometimes when there are no immigration options in the United States, we have to help people by sending them outbound and then bringing them back in.
Let's talk a little bit about the current state of immigration law. A number of people, or most people, are excited negatively about what just happened in the Supreme Court. Can you share with us the current status?
Sure. Well, as you may be aware, the U.S. versus Texas case was decided by the Supreme Court. It happened last Wednesday. And in that decision, it was a split decision, four Supreme Court judges for, 4 Supreme Court judges against. And it was a one-line decision. It was not very exciting at all. We were expecting, of course, to have this matter approved, especially in light of the fact that the prior program, which mimicked the program that was under question in the Supreme Court case, which was DACA, Deferred Action for Childhood Arrivals, is already online and has been online since December of 2012. Okay. So it was very disheartening to see that they could not make a decision, but in light of the political climate, number one, it's an election year, and obviously there are parties who are very interested in getting the Hispanic vote, namely, you know, I don't have to tell you where the Hispanic vote's going to go. And also, you know, there's, you know, President Obama has been very ardent and pushing to try to get another Supreme Court justice, you know, appointed, and unfortunately, he's encountered tremendous resistance. And I think that this decision was a culmination of bad politics. I think that in a different year, you would have seen something different happen.
So what does this decision do for immigrants now, particularly undocumented illegal immigrants?
Well, with regard to, again, there's DACA 1, the Deferred Action for Childhood Arrivals 1, that was put online back in 2012, and what that did is it gave individuals who were undocumented, who entered the United States before they were 16 years of age and who had been in the United States for 5 years, the opportunity to apply for work authorization and to be deferred essentially from removal. And it's a beautiful program because it essentially addresses the dreamers who were in the United States, who have grown up here and thought for all their lives that they were in fact U.S. citizens. And we have many people who came out of, you know, who came to us and who had been here for so long, and then they didn't know what their status was, and then all of a sudden we were working with them to try to rectify their situation. Now, what this Supreme Court case addressed was DACA 2, which was an expansion of DACA, which would have served about another, I think it was, they talked about something like another 2 million people, plus DAPA, which was really the new, that was the new announcement that was made by President Obama in November of 2014.
And what is DAPA?
So DAPA is Deferred Action for Parental Accountability. And that allowed any individuals who were in the United States who had green card children or U.S. citizen children to be able to get deferred action or prosecutorial discretion exercised, such that they would be able to get work authorization and be allowed to stay in the United States with the individuals in their families who had status. So, so it was really, and it's kind of interesting. I mean, it's really about family unity. That's really what it comes down to. And so, you know, so unfortunately now these 5 million or so people who would have been able to get a benefit from these two programs are now left in abeyance, unfortunately. The case has been kicked back to Judge Hainan in the Fifth Circuit down in Texas, and the restraining order, unfortunately, stays in place. And we just have to wait and see what's going to happen.
So would you say we have 5 million people that are living in fear of being deported in this country? Well,
we have a lot more than that. This program only addresses those particular 5 million who would have been able to benefit from DAPA and DACA. Supposedly, and I believe that the last census came back with something like 13 million. My humble opinion is it's even more than that, because even the U.S. Census is not perfect. And I think it could be closer to something like 15 million people. So really 15 million people here in the United States are without some form of status and need to rectify their situation.
So let's go to something very basic. What is an illegal immigrant, and is it the same as an undocumented immigrant?
Well, yeah, I mean, they're used interchangeably, and it's a really valid question. I think that when you say an illegal immigrant, to me, it means someone who has entered the United States without status. They have entered, you know, what we call EWI, entry without inspection. Those are usually people who have come over the border or have not presented themselves for what we call legally inspection. It means that they haven't talked to an officer at the port of entry and said who they are. And they're a different group of people from folks who have come in who were with documents and then whose documents have later expired. And I don't know that I've ever seen any statistics on how many people have entered without inspection and overstayed versus how many of the people who are here in the United States are what we call, you know, again, entered without inspection. I think that the big issue is, you know, of these people who came in entry without inspection, who are they? And obviously in this world where security and our borders and knowing who is here is a big concern, we don't know who those people are. We don't, and what I think the benefit, the great benefit to our country would be, is to put some type of benefit in place for these individuals to bring them out of the shadows and allow us to know who they are. We want them to pay taxes because, you know, there have been, I believe it was Pew, the Pew Group had done, the Pew Consulting Group in Washington, did they did a big report and found out that obviously the payment of taxes by these individuals would only benefit the economy, and knowing who these people are and bringing them out of the shadows would only benefit us from a security standpoint. So I think that there's a lot to be said for knowing who these EWIs, these entry without inspection folks are. Now, on the flip side, of course, then we have all these other people who have entered with inspection. They have documentation, but what they've done is they've become what are called overstays. And these overstays is very interesting now because this kind of feeds into the politics of what's going on today. These overstays, the way the law reads is that there's a section of the law which was actually written in 1996 under what's called IRA. I don't know that I'm going to be able to tell you exactly what it stands for, but it's the Illegal Immigrant and Reconciliation Act of 1996, something like that. And that was signed by President Clinton. And in it is a section called 212A9. 212A9 is the 3 and the 10-year bar. If an individual enters the United States and remains in the United States out of status for 180 days or more, then they are barred if they leave the country and try to get back in. So it's an automatic form of deportation.
So they won't. So what sense does it make to leave the country?
So exactly, exactly, and that's exactly what the problem is. So what you have is you have these people who've entered, they've overstayed, and they're being told that if they leave the country, if they've overstayed by 180 days, then they end up being barred for 3 years. If they've overstayed by 1 year, they end up being barred for 10 years. So they don't leave. That's exactly correct.
So does it matter if they stay beyond the date knowingly or unknowingly?
Well, a lot of them, a lot of people, when they go and seek legal advice with regard to their options, they're told I hope they would come and see a qualified immigration lawyer in time to be able to make the decision to leave in time so they don't become subject to the bar.
Right.
That's what we try to do.
That's what you would hope.
That's what we hope. Now, what President Obama has done to ease the pain of these bars is that he's implemented certain types of provisions. They're called waivers. So there are ways to get waivers of the 212A9 provisions, where what you can do is if you have a qualifying relative and you can show hardship, you can get a waiver of these bars. And we do quite a number of waiver applications, as do many of my colleagues. The key is that you have to prove that you have a qualifying relative. And what they're doing now is they're also opening up this waiver opportunity to the number of qualifying relatives is being expanded. So President Obama is doing the things that need to be done to be able to alleviate the pressure and to allow individuals to be able to get the benefits. But it's a slow process, unfortunately. And waivers are very restrictive. There are very discrete parameters on being able to obtain a waiver.
Is there a time limitation on when you can obtain a waiver?
There's not a time limitation on it. It's more that you have to be able to apply for a particular benefit. So, for example, if you marry, for example, if you've entered the United States, let's say hypothetically you've entered the United States without inspection and you marry a U.S. citizen and you don't have any other way to adjust your status, then what you can do is you can apply for a waiver. So now they call it a provisional waiver, where what you'll do is you'll know whether or not you have a waiver of that bar before you leave the country. So they'll tell the consulate that the waiver might be granted. The individual can go out, visit the consulate, and then they can re-enter the United States.
So let me make sure I understood because I might have missed this. Must it be before the bar that you apply for the waiver, or can you apply for the waiver as an illegal immigrant?
So, so the way it would work is that if you're in the United States and you know that the bar is going to apply to you, what you can do is you can apply in advance of your departure to be able to get the green card or the visa abroad, and then to re-enter the United States without that 3 or 10 year bar applying to you. So I call it the know before you go provision, because you'll know before you leave whether or not you're going to be able to make it back in. If you don't apply for that waiver and you depart, again, what happened in 1996 is that if you leave, you just can't get back in. So it's almost, again, a form of self-deportation. And again, that was under President Clinton. So, and I think that if you listen to Hillary Clinton's campaign rhetoric now, a lot of it, I remember back about 4 or 5 months ago, was really interesting. One of the speeches that she gave is she said, we're going to eliminate the 3 and 10 year bar within the first 90 days of my administration. That's what she said. And I was saying, well, that's really interesting. How you're going to do that, I'm not exactly sure, because it's regulatory. But if that's what you're promising, that's going to help a lot of people. So obviously, I think that that statement she made was clearly catering to the need of a particular population. So I think that, you know, she's on the right track if that's what she actually wants to do.
David, that's absolutely fascinating. So right now we're going to take a break, and then we'll come back and talk about a few more pointers that our viewers, to help our viewers navigate the system.
Absolutely. Great.
Thank you. We are here with immigration lawyer David Nachman, talking, of course, about immigration issues. We've talked earlier about illegal immigration. Tell us a little bit about how illegal immigrants can become legal, or what is it that they can do in this period of time about their status?
Right. So I usually start when we sit down. I think probably the best thing to do is to tell you sort of like when we sit down with an individual might
Sure,
be coming
please.
to our office because they might not completely understand the process and how it works. We have a little chart that we put in front of them, and it's like a snapshot of the U.S. immigration system. And I explain that, you know, you can look at the immigration system sort of as a spectrum. And a lot of people don't realize that there are different forms of status that a person can have. So, for example, on, let's say, the far left part of the spectrum would be that an individual has no status at all.
Okay.
And then as you move across that spectrum, you have what are called non-immigrants. Non-immigrants are individuals who come to the United States for a particular purpose to do something, and they have what's called non-immigrant intent. Non-immigrant intent means that they intend to leave and go back to their home country. It's actually a provision of the law called 214B of the immigration.
So how do you know they have non-immigrant intent?
Right, it's a great question. So the way you decide, it's like everything else in law, is that you take a look at what, obviously, what the law is an objective manifestation of subjective intent. And that's exactly what the law is. So what we do is we help them to understand that the government is looking for certain things, such as, do they have assets at home? Do they have family members at home? Do they have ties to the community at home? And these are the types of things that pull them back. So it's not really as important as why they're coming, but what pulls them back to their home country. And that's what allows them to get what are called non-immigrant visas. So we do things like get non-immigrant work visas, like H-1Bs and intra-company transfers, Ls and Os for extraordinary ability, and Ps for performing artists, and, you know, and so on. There are whole, actually, the non-immigrant visa classifications run from A through U on the, so it makes it very easy to do the analysis. And I go A through U for every single person to try to figure out what options are available for them.
Okay, so you were going to also give us so that's just one portion of the.
That's one, right, and then moving, right, and then moving to the next part of the spectrum, you would have what are called lawful permanent residents, commonly referred to as green card holders.
Okay.
Okay, and those are individuals who come to the United States who want to be here and live here and work here. And usually what our job is as immigration lawyers is to sort of move people back and forth between the non-immigrant visa classifications to buy them enough time to be able to jump over into the immigrant application world or the immigrant petition world. And what we do is we focus on what are called pre-certified classifications. While I love the U.S. Department of Labor to death, and I think they're doing a great job, it takes a long time for us to get our cases through the U.S. Department of Labor, where you have to prove that there are no able, willing, and qualified U.S. workers to take a job. However, many of the people who we have are highly, highly skilled workers. I mean, some of these people are coming to us with like 35-page resumes. Top folks at some of the pharmaceutical companies. They're unbelievable.
So explain to me, you used the word pre-certified. How does that apply?
Right. It
what
means,
really is that?
Exactly. So that means that what we're able to do is essentially go around the Department of Labor and to make applications in various visa classifications to avoid having to do a labor certification. So for example, an individual with extraordinary skills and abilities, or an outstanding researcher who might be working for one of the top pharma companies here in New Jersey, or one of the professors who's working here at Princeton, these folks qualify for probably the outstanding researcher classification, which doesn't require us to go to the U.S. Department of Labor and to show that there are no able, willing, and qualified U.S. workers who can take the job. And so there are a whole gamut of green card applications that we would apply for. And then there are also investor visas, and then there are also religious worker visas, and those all fall into the green card classifications.
Okay, but what is an investor
visa? Investor visas are a visa classification that allows individuals to make an investment of a certain amount. Usually it's between $500,000 and $1 million, depending upon where they're investing in the state. And they're able to generate 10 jobs for U.S. workers, and they're able to actively be investing in the business, and they can get green cards for that.
Okay, so if I understand you correctly, these fall within the green card classification. Exactly. But these are not considered immigrants. These are non-immigrants.
Well, they're actually immigrants.
Okay.
Those are immigrants. So yeah,
okay.
so immigrant, lawful permanent resident, and green card are all synonymous.
Okay.
Yeah, they're all synonymous. Okay. And then generally speaking, after about 5 years as a green card holder, you can apply for citizenship. So the things that, like I get the call in the morning, every morning I go into work and I get the call from the individual who says, I have this nanny and I want her to be a citizen. And I'm like, well, guess what? There are a couple of steps that you have to go through before you can become a citizen. So you have to get them through all of those steps. But going back to your first question, which really is what options are available to people who don't have status.
Yes.
So the first thing I think I really need to point out, which is the realistic view of the world, is that not everyone has an option. And oftentimes people will leave our office and I'll have to say to them, well, you know, unfortunately, you may not have an option today, but that doesn't mean that the law is not going to change tomorrow. And so, you know, that is some advice that we can, that we can provide. But there are many, many programs, and the only way that I can know what benefits might be able to be used for someone is if I sit with them and explore their background. Just by way of an example, one of the things is if a person has a member of their family who's in the U.S. military, what they could do is they could apply for what's called parole in place for military personnel. So if you have an individual in your family who is, who is in the active military or a veteran, they can apply for military parole in place. So that's one option. Another is that, and this is kind of interesting, this goes back to 2001, we always ask our clients if they ever filed, if they were in the United States before 2001, if they ever made a qualified filing before the, either the Department of Labor or the Immigration Service back in 2001, we're allowed to use what's called it was called the Life Act, and it was also something that President Clinton had implemented. Actually, what happened was President Clinton, and again, this is kind of historical.
Right, that's fine.
Yeah, President Clinton back in 1996 really did not do a tremendous justice to the U.S. immigration system. It was really, he hit it really hard.
So I understand.
And yeah, it was very bad. But what happened was in 2001, when he was leaving office, I think he felt guilty for what he did, and what he did was he implemented this thing called the Life Act. And the Life Act gave people the ability to make a filing, a qualified filing, before April 30th of 2001. And we see many people who come into our office who actually have these filings. And if they made these filings, what it does is it allows them to take that grandfathered benefit and to carry it forward and to use it today. So what they can do is, for example, they can apply for a benefit today and they don't have to leave the country. They can pay a penalty, which is a $1,000 penalty, stay in the United States and apply here without having to leave the country. So what essentially it does is it allows them to circumvent those bars that we talked about before, the 3 and the 10-year bar.
Right.
So 245I was a wonderful way for people who are undocumented in the US to be able to get status. So it works out very well. Another thing that we talk to people about, especially if they've been here in the United States for a long time, is the U visa. The U visa is it's a non-immigrant visa, but it gets you sort of into the direction of applying for a green card, because once you have a U visa for 2 years, you can apply for the green card. It works out very well. These are victims of crimes. So individuals who are victims of certain crimes, and the crimes are actually listed on the website. So it tells you what crimes qualify. And if you get a law enforcement agent to work to sign the Supplement B on the form, you can actually get this U visa status, and then you can get a green card. So we always inquire with individuals who come to our office whether or not they were ever the victims of certain crimes. Now, and everyone always gets confused because they always say to me, no, I never committed a crime. And I say, no, that's not what I'm asking. Right. I say, have you ever been the victim of a crime? And, you know, the crimes can arise, you know, in, of course, the individual's personal life, or it could also be in their business. So for example, a lot of folks who maybe work at bodegas, or, you know, folks who maybe work at liquor stores, or gas stations. If somebody comes in, well, wage is another issue. That's actually an interesting one, because the U.S. Department of Labor, probably, I think it was about a year ago, said that they would be willing to sign these supplements. So if individuals do have wage issues, they can bring it to the U.S. Department of Labor, and those people are considered to be victims in certain circumstances.
Because we're running short on time, let me take you to another issue, deportation.
Sure. Removal, right, yeah.
Removal.
Yeah.
Do the 5 million that were impacted by the Supreme Court decision, should they be worried about deportation? And if they
Yeah.
If they should be,
It's a great
what
question.
can they do to avert deportation issues?
All right. So it's a great question, and obviously these folks are removable. The best thing to do is talk to a qualified immigration professional. I know that the folks who come to me, if I can't find a particular option for them, I always give them my business card and I write my cellular telephone number and I say, use that in case of an emergency, so that they know.
So
Many
if they
of
have
the folks,
an advocate, if they
exactly, so
run
that they,
into a problem.
right, because the hardest thing is knowing where to get the right information, and you don't want to be doing that if you're detained or if you're picked up. You don't want that to be last minute.
So one of the best things they can do for themselves right now is to get some protection with an advocate. They
know who to speak to.
Know who to
Yeah,
speak
know who to speak to. It's very important
Okay.
to just have a business card that they're carrying around, or have access immediately to professional help in the event that this happens. But people who get picked up, let's say picked up, what is the likelihood of getting picked up? I think that's your first question. Is I don't think that there's tremendous likelihood of them getting picked up unless they're a priority. So President Obama did implement this priority system where he's going after criminals, and I'm sure you've heard about it. It's deport criminals and not families, right? So they're hopefully leaving families alone. But the fact of the matter is that if a person is removable, it's not so much, it is a possibility that they may get removed, but it's probably not a probability.
Okay.
The government doesn't have the money to be able to remove. To remove individuals costs something between $7,000 to $15,000 per person. If you take that and multiply it by 13 million, you're not going to have enough zeros on your calculator. You're going to get an error message because they don't have the resources to be able to do it. And that's what priority enforcement is all about.
And so you mentioned earlier in the green room about administrative priority. Is that what you're talking about now as a defense?
Exactly. Well, it's a prosecutorial discretion, which has been in the law for a long time. And it's actually the genesis of DACA and DAPA and DACA 2 have all been the prosecutorial memo that it was actually many, many years back. It was John Morton, who was in charge of Immigration Customs Enforcement, who listed out what he felt were the places where the government should enforce as opposed to wasting their resources. So what they want to do is they're saying, let's go after terrorists, let's go after criminals, let's go after folks who shouldn't be here. But let's leave other people alone. The people who are in the military, let's leave them alone. The people who are taking care of their sick relatives, let's leave them alone. The dreamers, let's leave them alone. Yes, they're removable. We understand they're removable, but at the same time, let's exercise prosecutorial discretion and let's refrain from wasting government resources in places where we shouldn't be wasting those resources. So that's what I think they call it the PEP program, the Priority Enforcement Program is all about. And that was actually announced by President Obama back in November of 2014, and it's in a memorandum that he issued on that date. Yeah.
So David, let's end with this. Can you tell us where you think the system is going to go?
Great question. So we're in an election year, and obviously the issue of immigration is clearly in the forefront. It's clearly on the front burner, and it's in everyone's minds. I believe that President or the candidate, President Clinton as a candidate, Clinton as a candidate is saying that she is very much in favor of comprehensive immigration reform. We've already had some really good proposals for comprehensive immigration reform bills. We have nice templates looking back. I think the Gang of Eight, and just so
Gang of Eight?
Gang of Eight, which was the 8 senators who got together. Senator Menendez, our excellent Senator Menendez from the state of New Jersey, did a fantastic job of putting together a wonderful template for comprehensive immigration reform. Unfortunately, they were unable to get that through the House, and it ended up dying. However, it still remains out there as an excellent opportunity, and I think that if and when the appropriate time comes, if we grab back on to that blueprint and push that forward, I think that would be an excellent way to solve some of the immigration issues that we have. Whether that is in the future, I can't read the crystal ball or the tea leaves, so I won't be able to tell you that, but I think that, again, I think that the blueprint is there. So if the government wants to do something, I think that they certainly have the springboard if that's what they choose to do.
Well, I think that you have left us on a hopeful note, and
I hope so.
have really informed us about the issues. So thank you very much for joining us.
It's my pleasure. Thanks so much for having me here.
Okay.
I appreciate it.
Thank you.
Thanks.